what are those considerations? Number one, Chapter 11 has good things and bad things on the day you file the case. You're going to have all these protections, but those protections may disrupt the way you do business. So you may be looking at what we call relief. You may be looking at options, be running into the courthouse to sort of alter what would otherwise occur as a standard. And so to explain that further, you file a Chapter 11. Now, like any other form of bankruptcy, you're not supposed to pay any of your debts, the pre-petition claims. That's the whole point of the case, right? Is we want to get rid of some of these debts. Oh, but what if I wanted to pay some of these particular vendors because I need them to continue to provide services, labor, food? Well, you're not supposed to. Even your employee payroll isn't supposed, by default, to be paid. So if the business files Chapter 11 and it's in the middle of a biweekly pay cycle, you're 1 week in and you file that, those employees would not normally otherwise get their wages. Well, that's not such a great plan if you think that everybody's just going to walk off the job and no longer come back to work if you're not going to pay them. So that brings us to what we call first day motions. First day motions are those things that need to be heard on a very expedited emergency basis to enable the debtor, the business, to have a little bit more smooth transition into this business bankruptcy. So there's a whole spectrum of first day motions. One of one we just touched on would be asking the court for permission to pay pre-petition employee wages so your employees can get paid. Another example would be creating what we call adequate protection for utility providers. So you're a business, you file bankruptcy. We would very much like it if they don't shut off the electric, the gas, and the water. So we have very clear procedures we have to follow to ensure that we can keep the lights on with those various utility providers. So we need to have determinations as to what kind of deposits they need to be paid, those things. Because you got to remember, we're not talking about possibly a $100 or even $300 a month electric bill. For example, I have a client right now whose electric bill is $20,000 a month. It stands to reason that the utility provider would like to know they're going to get their money or not run up more debt with you after the filing of the bankruptcy without certain assurances. So that's one of the things that you have to do. Another example, which gets a little complicated, but that's what's known as a cash collateral order. And what that means is, when you file the bankruptcy, you're not allowed to damage, destroy, use any of the collateral, any of the property that might be encumbered by a secured creditor. So if you have a business loan, and that business loan has a lien, they have the right to your accounts receivables, meaning monies that you're going to get in the future. You do a job for a client they haven't paid yet, but someday they're going to. There's a lien on your account receivables. When you file the bankruptcy, that incoming money you're not supposed to touch. Well, it makes it very difficult to operate a business in a bankruptcy without any money. How are we going to pay our future employee payroll? How are we going to buy new raw materials or goods inventory? How are we going to pay for logistics? All those things. You need money to do that. So you have to get permission to use that money that would otherwise belong to the secured creditor if they have a lien on your account receivables, on your cash. So that's one example. So what we're getting at is this is a far more complex and thought out process than something like a consumer Chapter 7. That when an individual files Chapter 7, for the most part, their life the next day is no different than it was the day before they filed bankruptcy. That True, they receive the automatic stay, and they no longer have to worry about creditors trying to collect the debts that are going to be part of their case. So if you're being garnished, the garnishment stops. If you're being harassed, the calls and the harassment has to stop. But you can go to work, you can make your money, you get to operate your life, generally speaking, the way you would have done before, and at the minimum, in a way better than the way the day was before, the way you want. It's not exactly that way when we talk about a Chapter 11 for a corporation, because with the good comes the bad. You get these protections in bankruptcy, but we have restrictions. We can't just do whatever we want. You don't get your cake and eat it too. So we've discussed that pre-planning is going to be one big step. If you have a company, if it's in financial woes, this is not the kind of thing where you want to go to an attorney and hope that you can file a bankruptcy the next day or even a few days later. They have no idea what your finances look like, how this plan of reorganization would even possibly work out, what first day motions are necessary, the time to draft those first day motions. The sooner is always better. Good foresight is going to be involved. We mentioned early on the need for accountants as a professional group. We'll get to that in a bit as to why they're critical, but generally speaking, the law firm is probably not qualified. They don't have experience. They don't want to do all of your books. You have CPAs for accounting and you have lawyers to practice law and go to court with you. Each one has a job. I don't practice medicine and doctors don't know the law. The point here is individual goals. So we have now filed this case. Day one, we filed our first day motions. Ideally, you're going to get in front of a judge on a very expedited emergency basis. So you can obtain interim, in other words, temporary orders on those first day motions. Doesn't mean that that's permanent or final. It does mean that you have to come back and revisit that later. And the reason is you can't get permanent relief when creditors haven't even had the right to review what's going on or object or get their say. So you file a bankruptcy on Monday, you're in front of a judge on Wednesday, you're asking to use cash collateral, it's only going to be a temporary order. It's going to be an interim order because we're not going to decide this whole thing on 72 hours notice. But it does give your debtor breathing room. I've read before an expression in case law that I thought was great, that you don't want the patient to die on the operating table. And so what they're doing is they're analogizing human surgery to a corporation. But the point being that you don't want this company to go under, to fail, while we're trying to save them and get issues sorted out. So speed and timing is always of the essence. We've filed, we've gotten in front of a judge, we've gotten hopefully the relief we want on an interim basis. What comes next? Next is going to be an initial report. Within 14 days of filing that bankruptcy, you have to file a whole flurry of things. Tax returns, profit and loss statements, balance sheets, checks for the prior 90 days, banking statements, all these things. It can end up being hundreds and hundreds of pages. But it's information you should have had from the client before you ever even filed the case. That when you were working with them, they needed to know this is the list of things we're going to need, and we're going to need it before we even file, or at the minimum within 14 days. You're going to get that done. You're probably going to end up back in court within the first month for the final hearings on those first day motions. All this is a controlled chaos. The dust doesn't settle in the first few weeks of a Chapter 11 case. But the goal is to reach new normal. The goal is to get to normalcy for that particular client, for that debtor, so that they can have the breathing room and function while you are able to figure out the long-term plan. We don't want to spend years in this. We don't want to spend even half a year, ideally, depending on the complexity and size of the case, waiting to get a plan proposed and then confirmed. The faster you can get in, the faster you can get out, the better the odds of success, as well as the less overall cost for attorneys, for accountants, the better the chances for the debtor. So what is the big picture? What's the big goal? Well, the big goal The real brewing fight is the plan. But before the plan, we're going to have the disclosure statement. Now, in cases that qualify as a small business debtor for Chapter 11, which means you've got less than $2.6 million in total debt, you can file those at the same time. You can file your disclosure statement, you get presumptive approval, and then you can worry about the fight over it later. But in most Chapter 11s, meaning any Chapter 11 that's not a small business debtor, where you have over a total of $2.6 million in debt, which is a lot of money, but it's not a lot of money when you think about corporations, then you're going to have to receive approval on the disclosure statement first. That comes before the plan. And a lot of times, objections to the disclosure statement are really just thinly veiled setups to fights about the plan, that if creditors have a problem with the disclosure statement, they're probably tipping their hat to where their same arguments would be about the plan. So the disclosure statement is going to be bigger, it's going to be thicker, it's going to be longer than the plan. But it's saying, in essence, the same thing. It's laying out all the financial affairs of the debtor. It's explaining what you hope to do, the classes of creditors people are going to be assigned to, the treatment for those different classes. Are they going to get paid? Are they not going to get paid? How much are they going to get paid? How long it's going to take to pay them? Those kinds of details all would go into a disclosure statement. A lot of legal tests involved, a lot of time spent preparing those types of things. The two tests that you're going to need that accounting group for, and you're going to want their experience and reputation on your side should they be called to testify and defend this work product, is a liquidation analysis and a feasibility analysis. Meaning, in a Chapter 11, the unsecured creditors must receive at least as much as they would receive in a Chapter 7 case. We call that the best efforts test. So you're going to have a top-notch accounting groups to look at your company and give you a number as to what you would be worth if you were liquidated. If you went into Chapter 7, we sold everything, we paid off the secured creditors, paid off priority claims, we paid off administrative claims. How much make it to the unsecured creditors? Because that's going to be a benchmark in the Chapter 11. Feasibility is basically, can we do this? Is what we say we're going to do really what we're going to be able to do? Cash flow projections, business forecasting. The law firm isn't likely qualified to do those types of financial projections. As I said, they're not usually CPAs. They don't have that experience. That's why you work hand in hand with accountants. Also, the law firm isn't going to be one on the stand testifying about the accuracy, the validity of the plan if it comes to it. So now you've gotten your disclosure statement approved. Now is the plan. Well, what is that? Well, we just mentioned that the disclosure statement basically incorporates everything that would go into the plan, and the plan is as it sounds. It's how this company is going to reorganize itself and then exit the Chapter 11 bankruptcy. The goal is to get it approved. That's what we call confirmed, to have a judge say thumbs up or thumbs down. And that's just like in a Chapter 13, which we haven't had a chance to talk all the way through about Chapter 13's, but it is somewhat similar in just a more simplified, watered-down version of Chapter 11. We don't have the complications, the length, and the cost, which is a good thing for individuals. But as we noted, only individuals can use Chapter 13. Businesses can't. How does a plan get confirmed? There are two ways. One option is by approval of the creditors. You're going to send out ballots, and then you're going to receive back votes. Now, you don't have to have votes from a class that's considered unimpaired. Well, what is that, Jason? What the heck is classes? What does impairment mean? We've talked previously that you have order of creditor priority, that just because someone's owed money doesn't mean they're equal to everyone else. So where you place them on the hierarchy is their class. That's what matters. And if that class gets paid out in full, they get satisfied, they don't get a vote on the plan because it's assumed that they're made whole. They're good to go. And then you go down to the next class and so on and so forth. We don't go from one class to another in payments until the class above it is fully satisfied. So there's always going to be, well, not always, but you're typically dealing with a class that's unimpaired, below it a class that's partially impaired, and maybe below that multiple classes that are fully impaired. But that top tier of impaired class will have a vote on this plan. If they approve it, and the way their votes are going to be cast is based on the pro rata share of the creditor for that class, meaning if you have 10 creditors total, and each one has $10,000, the size of the pool is $100,000, we would obviously need 6 creditors to get over 50% to have it approved. On the other hand, if one creditor was $50,000 out of $100,000, you just need his vote, and you're good. So you're going to get a pro rata share of the creditors for the class. If they approve it, you have passed the plan, you've gotten it confirmed. Maybe they don't like it, maybe they don't approve it. Then that's the other way. And that's what's known as a cram down. The cram down is, as it sounds, cram down their throat. They don't like it, but they have to take it. That's why it's critical that you did your work on the disclosure statement and you can pass the 2 tests we talked about, best efforts or liquidation test, feasibility. If you can convince a judge at a hearing, confirmation hearing on the plan, of those factors, you can have your plan approved even over the dissent of the unsecured creditors. They don't have to like it if you did your job right. So that is when then you begin to exit bankruptcy. That is when the plan is confirmed, the business is reorganized, they will receive their discharge, and they're able to move forward. They still have a lot to do. They may be making plan payments for many years, could be 5 years, could be 7 years, paying off these debts. But they no longer have to worry about what they're going to do. That big fight has been done. Looming is over. Case may be closed. You may no longer have to make trustee reports. You may no longer have to pay the quarterly trustee fees. So we've touched on, in a nutshell, today's episode, corporate or business bankruptcy. We've identified that there are 2 chapters, Chapter 11 and Chapter 7. We mentioned Chapter 13 is only for people, not for businesses, can't use it. Chapter 7 is liquidation. If you do that, you're going to wind up affairs, you're going to go away. On the other hand, if you want to save a business, the only option is Chapter 11. We've gone very quickly. We've covered a whole ton of information, and it really doesn't even begin to scratch the surface of the considerations involved, but we laid out a basic roadmap. Friends, this has been a wonderful episode. I hope you've enjoyed it, and I hope you've learned a whole lot. Tune in next week for another episode of The Legal Breakdown. We will continue our series in assisting you in knowing more about the law. Have a great week. Be safe. This is Jason on The Legal Breakdown.